Welcome to this session, the Prairie Dogs, the Endangered Species Act, and the Limits of Federal Power. I know about as much about prairie dogs as most of you do, so I'm not going to take any time to introduce them, but this has to do with the Endangered Species Act and its reach and jurisdiction, and prairie dogs which are restricted in distribution to one state. So with that, I will introduce our first speaker, is Steve Forrest with Defenders of Wildlife.
Thanks, everyone. It is a very interesting constitutional issue. I'm going to let my colleagues who will come after me talk about the legal aspects of that consideration. I'm going to cover mostly about 20 minutes of biology about not only the Utah prairie dog, but the prairie dog ecosystem in general, which is I think probably many of you are not familiar with this ecosystem. Not many are, because mostly it's gone. It's about 98% vanished, but at least at one time, not so very long ago, it was comprised, at least out on the Great Plains and a lot of the intermontane valleys, one of the most significant ecosystems in North America. There are 5 species of prairie dogs. The large green area is the black-tailed prairie dog. I'll run through all of these species and the various threats to them, but I just want to give you some feeling for where they occurred. 5 species. We've got the black-tails here, white-tails here, Gunnisons. There's our Utah prairie dogs there, confined to that single state, and a little isolated pocket down there of the Mexican prairie dog. Originally, as folks, mostly Europeans, came upon the North American continent, they found this species out on the prairies and plains. They were quite in admiration of it. A lot of early descriptions of early naturalists, early explorers, talked about the industriousness of this species. People related to the fact that they are, in fact, a colonial species. They're group-living individuals. They have an ecology and behavior that relies on community. They live in family groups called coteries, so they're very closely knit. They have a very detailed communication system. We know now that, in fact, they have a language with various phrases for different kinds of phenomena that occur out in their natural environment. Very complex system, and I think that was appreciated by early naturalists, or early explorers and visitors, even the early pioneers. But it wasn't long after the settlement of the northern Great Plains that, with, in fact, the encouragement of the federal government, that we embarked on large-scale campaigns to eradicate prairie dogs over most of their range. And that's how we have, in fact, pieced together some of the distribution historically, is through the very meticulous records kept by the Bureau of Biological Survey in the early 1900s to the 1920s and 30s, as they documented the effort to essentially, the goal was the extinction of these 5 species. We know that they probably occupied historically about 17% of that large geographic area that I showed earlier. It's a tremendous amount of area. They are ecosystem engineers, as I will talk about later. They have a host of species that are associated solely with that prairie dog ecosystem which they created, which is short grass and a very complex burrow system, so a subterranean system that on the more or less 2-dimensional grasslands created a 3rd dimension of structure that you don't, and we know in a lot of forest ecosystems, for example, there's a lot of stuff that's up in the canopy. Well, out of the Great Plains, it's the stuff that happens underground. So these wide-scale rodent control campaigns eliminated essentially about 100 million acres of this habitat out in the Great Plains. Today, we have other threats. and these are more recent. Plague was introduced into North America, we think in about 1903, came in through California, and has slowly spread throughout the West. I'm going to talk, if I've got a minute, a little later about plague and what we now know, very brand new information about how plague has transformed that ecosystem as well, but it is also a threat to prairie dogs who seem to have no natural immunity to it, and often entire populations will be wiped out in a matter of days when they encounter plague. Got other additional causes of decline. We've got conversion, land conversion, in other words, shopping malls that will wipe prairie dogs out, crops, urban sprawl, and then we have prairie dog shooting down there in the lower right corner. A lot of people think that's people shooting prairie dogs, but it's actually can shoot back, and it's creates quite a bit of problem. So I'll just run quickly through these prairie dog species, as I mentioned. We've got the Mexican prairie dog, lives down in that Coahuila. That used to be, about 200 years ago, there were probably anywhere from 350,000 acres or so. Today, there's only 54 colonies left, 80,000 acres. The Mexican prairie dog is listed as endangered pursuant to the ESA and also under Mexican law. It's critically endangered. Again, as I mentioned, Mexico has legal restraints on killing them, and they are listed under the ESA. They still continue to lose habitat. Frito-Lay had a proposal a couple of years ago to grow potatoes there for the potato chip industry. They were going to wipe out about 25% of the habitat down there. Fortunately, got wind of that through our Mexican colleagues, and we were able to stop that. The Gunnison's prairie dog, essentially there are two kinds of general groups, a subgenre, if you will, of prairie dogs. White-tailed group and the black-tailed group. The Gunnison's prairie dog are in this white-tailed group. They occur in kind of southeast or southwest Colorado, mostly, and a bit of New Mexico. About 24 million acres historically, now down to somewhere between 340,000 to 500,000, so a reduction of about 98% in their distribution. I might also add, I'm giving you areas that they occupy instead of individuals. It's kind of an artifact about how we in the biology business count prairie dogs. It's often in the nature of how many acres they occupy as opposed to how many there are, because they are difficult to count. When I get to Utah prairie dogs, we're talking about individuals. The Gunnison's prairie dog has been petitioned for listing. The Fish and Wildlife Service has gone up and down on this for a while. They said it was warranted, and a very famous case where they tried to split the population after some additional litigation. It was determined that, in fact, the Fish and Wildlife Service could not split the population, but on remand, the Fish and Wildlife Service found it was not listed. That was just recently in 2013, and there are ongoing efforts to continue to address that issue. Like the other prairie dog species, again, development, plague, shooting, and ongoing poisoning continues. The white-tailed prairie dog itself, about 10 million acres, now down to about 800,000 acres, a 92% reduction in its habitat. It's been petitioned for listing under the ESA on more than one occasion. It kind of goes back and forth. 2010, Fish and Wildlife Service found it not warranted. That was overturned just recently in 2014. It's been remanded to the agency, so they are considering now whether it should be listed under the Act. Same suite of threats, with the addition of whitetails occur in a lot of the oil and gas producing areas in Wyoming, and so that is a threat. The black-tailed prairie dog, which was the most numerous and widespread of the 5 species, probably about 100 million acres historically, now down to about 1 to 2 million acres, again about a 98% reduction in its habitat. It's been petitioned for listing. It was found warranted in 2000, and then through some interesting political manipulation, maneuvering, was found not warranted in 2004. Was petitioned again in 2007, found not warranted in 2009. The state of Arizona lists it as endangered. In fact, it was extirpated in Arizona, but it's been recently reintroduced.
Sir, Sir?
Yeah.
Could you explain those legal terms for us non-lawyers?
Oh. And which ones would you like? The warranted
All of
and
them.
warranted?
I don't understand what that meant.
Okay, I will, so the Fish and Wildlife Service is often asked through a petition that's presented to us. They can find that there is sufficient information that warrants the species being listed under the Endangered Species Act. And what often happens today is that because the list of species is so long, there isn't adequate resources on the part of the federal agency to actually go through the steps to agree that it is in fact listed. In other words, to go through all the processes and so forth that are required to list it. So a species getting on the list today, more or likely than not, gets put at the bottom of the line. There's a whole bunch of species ahead of it. And the Fish and Wildlife Service is processing through all these applications and getting to them as best they can. So what they do is they say, well, this species probably deserves listing. Everything we can find from the petition and other information suggests that it should be listed, but we don't have the resources right now to list it. So we're going to say that it's warranted. We'll put it on a special list, the candidate species list, and we'll get to it when we can. So that's part of what's going back and forth here with all these species. Some of them are on the list. Some of them, I guess my whole point about these various species is that all of them probably, at least in some degree, are vulnerable. Some of them are recognized as critically vulnerable, and those have listings under the Endangered Species Act. In other words, they've been listed. And others are either awaiting listing or awaiting decisions about whether to list them.
Thank you.
Yeah. And then here's our buddy, the Utah prairie dog. Probably 200 years ago, there were probably 100,000 adults. And a very generous estimate would be that about 30,000 adults and 7,000 acres worth of colonies. They are listed as threatened under the Endangered Species Act. They came into the ESA as an endangered species in 1973. So they're one of the first species to be listed under the ESA. They were downlisted in 1983 based on some improvements in the numbers of individuals. They were again kind of readjusted in 1991. And once more in 2012, some adjustments to what they call the 4D rule. So threatened species get a different kind of treatment under the Endangered Species Act than endangered species. The service is fairly constrained in what it can allow in terms of what we call take. That means the allowable amount of individuals that can be killed or manipulated or the habitat changed. And under the threatened listing, the service can prescribe. It basically comes up with a set of regulations. So this is how we're going to treat this animal. It usually allows more generous take provisions, and that's the case for the Utah prairie dog. It has, I think, incredibly generous take provisions. And it allows some other management that is probably not, or is more flexible than the endangered designation allows. Now there are also HCPs, there are habitat conservation plans. This is another tool under the Endangered Species Act, adopted several years ago, allows the service to enter into agreements with private individuals and local governments to come up with a management plan for that particular species, which then allows some flexibility in the take rules. It often also comes with some incentive packages to provide financial incentives for, we could call it damage that the species may be inflicting on economic interests. Again, habitat loss, plague, livestock grazing, all threats to the Utah prairie dog. In the case of the Utah prairie dog, what often is the case in terms of, and I call this a threat because under the 4D rule, a lot of Utah prairie dogs are, there are provisions that allow someone to come in, trap up the prairie dogs from someplace and try to take them to another habitat. In a lot of cases, that's sub-marginal habitat, and it's not where the prairie dogs necessarily would go on their own, but it's usually to federal land or other protected land that allows for where prairie dogs are tolerated, or in some cases in the federal lands, they're protected under other federal laws. This is an old map, 1913 map of prairie dogs. I know it's probably difficult to vision, but all the fuzzy stuff basically is prairie dogs. The fuzzy stuff up in the northeast corner of the state was white-tailed prairie dogs, but it gives you some idea about the distribution of Utah prairie dog. Today, this is the current distribution. In other words, it's as we note, and which is the cause for this panel, confined to the state boundaries of Utah in that southwest corner. Again, a number of colonies, and that those areas that are we see the historic range is the lighter color, the warmer colors represent more recent distributions, and that is not the total area occupied. That is the area within which a number of these very small colonies occur. So it's a lot. If one were to draw it out, there would be quite a bit less. The management of Utah prairie dogs and the recovery goals. So again, for those of you not familiar with the ESA to a large degree, for all listed species are supposed to have a recovery plan. Not all do, but that is one of the goals of the ESA, is to promote planning on the behalf of endangered species. Recovery goals always set out some target, usually a population target. Sometimes it's called a viability target. I would argue in the case of the Utah prairie dog, this was, again, this particular numerical population target was set 20-some years ago. I don't think it's had the kind of scientific scrutiny that it probably deserves in terms of whether that number actually represents a sustainable population over the long term, given the threats to the Utah prairie dog. But nonetheless, you can see that the population, and just look at that purple line, that's the cumulative total. It's been going up and up, and right in here, 6,000 was the target level that the Federal Recovery Plan says is the level at which prairie dogs need to be for 5 years in order to be delisted. In other words, if the population maintains that threshold for 5 or more years, then the service will entertain a petition to take the prairie dog off the list. There is another set of conditions that has to be met. There are 3 management units, and so it's not simply just the absolute number of prairie dogs, but the distribution as well. They have to be at least 2,000 prairie dogs in each of those management units. And I might also add, this is not the total actual number of the Utah prairie dogs. As I said, they're probably 20,000, 30,000. These are standardized counts of adults in the spring. So this is something that's replicable. The agencies can go in and do this year after year at the same places. It's a kind of sampling regime, if you will. And that has been what is the agreed upon level. So if they go in and count in the spring, in each of these management units, find 2,000 prairie dogs, And they find that over a period of 5 years, then the service will entertain a petition to delist. So what's the big deal about prairie dogs? I mentioned they are ecosystem engineers, but they are also ecosystems unto themselves. And this was, in fact, along with probably the American bison, which are synergistically related to prairie dogs in many ways. Bison created the conditions often for prairie dog occupancy through their grazing behavior. But prairie dogs also, through their grazing behavior, create situations where bison preferentially would go to prairie dog colonies to graze, particularly early in the spring. Prairie dogs love to have a pool table, flat environment. They sit up on their mounds. They call to each other. It's part of their communal defense against predators. I work primarily on that guy in the top part of that picture, the black-footed ferret, which is, because of the decline of prairie dogs, is now itself a critically endangered species. I began work some 30 years ago on ferrets. We used to say, if you've seen one ferret, you've seen them both. And now doing a lot better, but still today, even today, the primary threat the continuing threat to the black-footed ferret is lack of habitat. In other words, we have so degraded its habitat that it remains difficult to recover ferret populations. But not so. So we have a whole suite of predators above the prairie dogs: ferruginous hawks, coyotes, badgers, bald eagles, golden eagles, you name it. The prairie dogs are kind of the popcorn of the prairie. Everybody shows up there. It's a highly stable and productive food resource for a lot of carnivores, or was. Probably historically, I think we've calculated it as something 2 million metric tons of biomass were produced in prairie dog biomass produced on these towns, which fed a lot of predators. It's all gone now, or the majority of it is. But prairie dogs are still influential through their herbivory clipping. They changed that ecosystem. There are other species that don't eat them that rely on the ecosystem characteristics. Mountain plover, that bird in the lower left that's been petitioned for listing a number of times. Swift fox, again, another species that's been petitioned for listing and is vulnerable in almost all the states. The burrowing owl, another species that is likely to be listed in the near future. Ferruginous hawk, another sage-grouse specific predator. And then we have a lot of insects that are, and invertebrates and so forth. They create unique patches of grassland, and this is a very dynamic system. They create a lot of edge. They're extremely important on grasslands. And when we lose those, we definitely have obligate species such as the black-footed ferret that are endangered themselves as a result. But we also are losing probably a lot of the richness of the prairie dog ecosystem. We've had changing attitudes about them over time. As I said, the federal government promoted poisoning, and they really, it was kind of a Smokey the Bear thing. They really pushed this idea that prairie dogs were pests, and they pushed that notion on people, and it was adopted over time. It wasn't until the 1990s or so that at least the scientific community recognized this keystone role. What's a keystone? It's an animal that has a disproportionate impact to its numbers on the landscape. And prairie dogs certainly fulfill that role. They're kind of like, I guess you could say they're almost like the coral reefs of the grasslands. And then more recently in the 2000s, a rise of advocacy for protecting them. So why do people keep continuing to dislike them? They eat grass. That's the primary reason. They compete with folks raising livestock because they eat the forage, and they're very obvious. More, I think importantly, they're a symbol of loss of control. The federal government, particularly in the case of the Utah prairie dog, has come into the state of Utah, and as so often happens in endangered species cases, it's this fear of loss of local control. They conflict with other land uses, and there still is fear of disease. And I don't have time to talk about plague, but we now know just in the last year or so that plague has probably it transformed that landscape in a way that we weren't aware of earlier. It may be a super challenge for us to recover prairie dogs in the face of that. And climate change, of course, we don't even haven't even scratched the surface on that, and it probably is going to have big impacts on especially arid adapted species as the Utah prairie dog. Thanks, and I guess we'll move on to the next one.
Okay, our next speaker is Patrick Parenteau with Environmental and Natural Resources Law Clinic at the Vermont Law School. Thank you.
Okay, so buckle your seatbelts, we're going fast. So, this is a fundamental conflict, folks. It's either golfing or prairie dogs, one or the other. It's always that way, isn't it? The little fish versus the big dam, jobs versus owls. What ball? Where's the ball? Did you see the ball? I don't see the ball. That was supposed to be humorous. Okay. So, the Endangered Species Act, right? Who was the champion of the Endangered Species Act? That animal rights activist? Richard Milhouse Nixon, right? 1973. So, what is it? From the most narrow possible point of view, it is in the best interest of mankind to minimize the loss of genetic variations. This is a law about evolution. This is a law about natural selection. This is a law about the subject matter of evolution. Genetic diversity, species diversity, ecosystem diversity. It's all about diversity, starting at the genetic level. The reason is simple. They are potential resources. And I love this line. This is Lee Talbot, now departed. They are keys to puzzles which we cannot solve and may provide answers to questions which we may not have yet learned to ask. The inchoate value of things we don't understand. Statement of policy. Congress finds and declares that various species of fish, wildlife, and plants in the United States have been rendered extinct as a consequence of economic activity and growth and development, untempered by adequate concern and conservation. This is a law aimed at economics and economic activity. The economic activity driving species after species extinct. This is not just a national law, it's a global law. This law was enacted at the same time that the United States last hosted an international gathering in Washington, D.C. that produced a convention that we actually signed and ratified. The Convention on the International Trade in Threatened and Endangered Species. This is a trade law. This is about trade. This is about commerce. This is about economic growth and development, and the kind of economic growth and development that's destroying the seed corn of the economy, the ecosystems from which all material wealth come. The purposes of this chapter are to provide a means whereby the ecosystems, 1973, folks, upon which endangered species and threatened species depend may be conserved. to provide a program for the conservation of such species and to take such steps as may be appropriate to achieve the purposes of the treaties and conventions set forth in subsection A. That's CITES and others. The Endangered Species Act is based on a whole host of constitutional authority at the federal level. The Property Clause, a third of the nation's land are owned by the federal government. The Commerce Clause, the Congress shall have authority to regulate trade among the states, foreign governments, and Indian tribes. The Tax and Spend Clause, which saved Obamacare, because the federal government can raise funds and spend funds. And of course, the little-known power that people sort of forget, the Necessary and Proper Clause. So, lots of constitutional sources of authority for the Endangered Species Act beyond the Commerce Clause. Has the federal government been involved in wildlife conservation? Is this the first time in 1973 or 1976? Is it 1963 that the federal government got in the wildlife game? No. No. The federal government's been involved in wildlife conservation, wildlife management, regulation of take for a very long time. This was the Supreme Court case recognizing that this is a concurrent authority realm, a cooperative federalism realm, where states and federal government share authority over wildlife. Not one or the other, share authority. And of course, where Congress has concurrent authority under the Supremacy Clause, it ultimately has the authority to preempt state law. The Lacey Act, 1900. The Migratory Bird Treaty Act, 1918. The Bald Eagle Legal Protection Act, 1940. The Endangered Species Act, 1966. Marine Mammal Protection Act, 1972. What do they all have in common? They're all about trade. They're all about take. What's take? It's killing. Okay? It's hunting. It's trapping. It's trading in live, dead parts. It's all about commerce. Nationally, internationally. Import, export. Both ways. Always. Who's this guy? The godfather of biodiversity on Earth. Biodiversity conservation. E.O. Wilson. He has some things to say about this. We should listen to what he has to say. The traditional econometric approach weighing market price and tourist dollars will always underestimate the true value of wild species. Always. None has been totally assayed for all the commercial profit, scientific knowledge, and aesthetic pleasure it can yield. We used to, when we clear-cut, liquidated the old-growth forest, the magnificent, temperate, old-growth forest of the Northwest. We used to burn a skinny tree in the forest called the Pacific yew, because in the silvicultural text it was called a trash species. To be gotten rid of, to be cut, piled, and burned, and replaced with plantations of Doug fir, softwood, for the foreign market, for export. So we liquidated a once great resource for export. The Pacific yew, it took a while, scientists monkeying around in the laboratory to discover there's a thing in the bark of the Pacific yew called Taxol. Taxol is now a $2 billion a year cancer-fighting drug. You see about, we don't know the questions to ask and the value of things that we don't understand. But of course, wouldn't you know it, the first challenge to the Endangered Species Act, under the Commerce Clause. This is our charismatic megaphone. It's always this way. You know, the Delhi Sands flower-loving fly, the only fly on the endangered species list. Now, it could have been the Dwight D. Eisenhower fly, right? Or the Ronald Reagan fly. But no, it has to be the Delhi Sands flower-loving fly. We're here today discussing an issue that most of us thought had been settled for a long time. This is the first of 5 cases I'm going to show you. 5 different critters. This issue of whether the Endangered Species Act is constitutional under the Commerce Clause has been litigated 5 times in 4 different circuit courts. Every single court to have considered the question until now, until Jonathan came along, about whom you'll hear more in a moment. And credit to Jonathan and his team for a very shrewd lawsuit, picking an intrastate species, kind of fairly friendly forum, and doing what no other lawyer who's ever tried it has been able to do, which is to secure a decision ruling that as applied on private land to an intrastate species, the Endangered Species Act is unconstitutional. But these cases, 5 of them, by different judges of different persuasions, appointed by different presidents in different locations, some conservative, some moderate, some liberal, a whole melange of the judiciary, 5 times have rejected arguments that the act is unconstitutional, and even more significant, 5 times the Supreme Court has refused to review the issue. I'm going to take you through this history, this trip down memory lane, with the idea of this. This is an interesting question, and it's a tricky question, and it's a lovely law exam question. And what you'll see with the excerpts I've pulled from these cases and these decisions is not everybody agrees on why the act should be upheld under a challenge under the Commerce Clause, but everybody so far has agreed it should be upheld. In science, you might call these different tests, different rationales, different theories, tested by different means, all reaching the same conclusion, robust. That's what science looks for. Different lines of evidence, applying theories to data, testing, retesting, and testing. Every time the act's been tested so far, same conclusion. The baby poop brown little section on this map is where all the flies are. That's all the flies in the world we got for Delhi Sands flies. That's it. That little strip in San Bernardino County, California, that's it. So this is a multi-species habitat conservation plan. You just heard Steve talk about one of the flexibility mechanisms under the Endangered Species Act being habitat conservation plan. This is one, and it's a multi-species plan. California is a leader in community-based biological planning. Good thing. This is Judge Patricia Wall, now retired. She was the first judge, the first panel, to consider the question, can Congress really protect the Delhi Sands flower-loving fly on the baby poop brown slice of San Bernardino County? Or not? Judge Wald actually thought, if you remember your constitutional law, you remember the 3 tests of the Commerce Clause, channels of conservation, instrumentalities of conservation, and substantial effects on interstate commerce. She actually thought the channels of interstate commerce would fit, but she also went on to say, the taking of the fly, taking means killing, by either directly squashing, fly swatter, anybody? Or bulldozing, or building Walmarts, God knows. We don't have enough Walmarts. We've got plenty of flies, even if there's only a few hundred, but we could sure use another Walmart. So whatever the means by which the fly dies, direct, indirect, it's a take. The taking of the fly can be regulated by Congress as an activity that substantially affects interstate commerce because it's a product of destructive interstate competition, the race to the bottom concept. States competing for economic development by saying, come to us, we don't care about the fly, build here. Because it is a principle deeply rooted in the Commerce Clause jurisprudence that Congress is empowered to act to prevent destructive interstate competition. One of the famous cases, of course, is Heart of Atlanta Motel, which said, no black people need come here and sleep. And Congress said, no, you can't do that. You're going to have to let the black people into your motel. She was relying on this law, 1977, Surface Mining Control Act. And this is a law that was tested under the Commerce Clause and went to the Supreme Court in 2 different cases and 2 different issues under SMCRA, as we like to call it. One of which, Hodel versus Virginia, upheld the approximate original contour. That's the reclamation requirement. Now, it forces you to engage in some magical thinking, okay? Because if you've ever seen what they're doing in Appalachia to get the coal out when they've blown the tops off of 500 mountains, a little hard to imagine how the approximate original contour idea has any application. But bear with me and just assume approximate original contour has some meaning somewhere. So that's all about a local thing. That's all about this mine, in this location, in this state, in this county, in this watershed. And that's what the approximate original contour requirement of the Surface Mining and Control Act is all about. How about prime farmland? It doesn't move. You know, it just sits right there and does what prime farmland does, which is grow things. So the act was upheld by a strong majority of the Supreme Court, even though it was dealing with intrastate activities, because of the pollution from the mine was the trigger, right? You mine here, the conductivity and the selenium goes downstream across the state border to another state. That's what Congress was trying to get at, and the same idea that Judge Wall applies to the Endangered Species Act. Judge Henderson, concurring, said, well, I don't know about that, destructive nature. I do get it about ecosystems. And I do get that ecosystems are interdependent. And I do get that if we lost all of our ecosystems, our economy might be in trouble. So I can kind of put that whole thing together and say, in gross, it is reasonable to conclude that the extinction of one species affects others in their ecosystems. You saw Steve illustrating that. And the protection of a purely intrastate species, like the fly, will therefore substantially affect land and objects that are involved in interstate commerce. There is therefore a rational basis for concluding that the taking of endangered species substantially affects interstate commerce, so that Section 9, that's the taking provision, is within Congress's Commerce Clause authority. Okay, now we're done with the fly. Luckily, the next case up is a little more charismatic. So, okay, the red wolf, Canis rufus, one of the most endangered species of wild canids in the world, probably the most endangered. The only other competitor is the Ethiopian wolf. And I think you'd admit, pretty handsome. They used to be here, but Fish and Wildlife stole them and took them to North Carolina. Don't ask me why. You probably know better than I. Why they were snatched and relocated from Louisiana, Texas Gulf Coast. There were only a few hundred. And now they're in the Albemarle Peninsula in about 2 counties of North Carolina. And there's just, again, a few hundred of them left. So now, new panel of judges, Judge Wall, Judge Henderson, Judge Sentell in dissent in the fly case, D.C. Circuit. Well, what are you going to expect out of D.C.? Yep. Now we're in the 4th Circuit. Okay? One of the most conservative circuits in the country. And here's our guy, J. Harvey Wilkinson III. Short list, Supreme Court, 2 different Republican administrations. Very smart, very able, but conservative by everybody's estimation. But he likes wolves. Because the taking of the red wolves can be seen as economic activity. So first trigger. Think of the triggers I've been saying. Wald thinks maybe even channels of commerce works. He certainly thinks destructive nature of interstate competition works. Henderson thinks ecosystems looking at things as a whole and the value of individual species in the context of the big picture cuts it. Now we see a different rationale emerging, which is this is really about economic regulation. And that makes all the difference in the world in Commerce Clause jurisprudence. If you can say that the object of the statute is economic activity, aimed at economic activity, you get a much broader view of federal power, and you can aggregate the sum total of Congress's authority over the entire class and category of activities being regulated without regard to how minimal or individual or intrastate and individual activity might be. So this was important. Economic activity in the sense considered by Lopez and Morrison, those are the 2 principal Rehnquist-era Commerce Clause cases that struck down federal laws on the grounds that they exceeded Congress's authority. The individual takings may be aggregated for the purpose of Commerce Clause analysis, while the taking of one red wolf on private land may not be substantial. The taking of red wolves in the aggregate have a sufficient impact on interstate commerce to uphold the regulation. This is especially so, whereas here the regulation is about one part of the broader scheme of endangered species legislation, not just nationally, globally. I love this part. Many tourists travel to North Carolina throughout the country for howling events. You ready to howl with me? Ooh! There you go. Evenings of listening to wolves howl accompanied by educational programs. These howlings are a regular occurrence at the Alligator National Wildlife Refuge. The Endangered Species Act was motivated in part by the need to extend takings regulation beyond the limited confines of federal land, the prohibition of takings on private land, was critical to the overall success of the ESA in halting and reversing extinction. You know this guy? New Orleans people ought to know this guy. Louisianans certainly know this guy. Who is he? He's the nutria. Now you know why his teeth are orange. Look at all those carrots he's eating. Well, guess what? The nutria are in North Carolina. The nutria are everywhere. Thanks for bringing them into the country, everybody here in Louisiana. Now they're everywhere, eating everything. Except, you see, and they do a lot of damage, a lot of economic damage, you see. But guess who eats them? Yeah. Well, red wolf loves them. Eats them right up. So, who can deny protection for these guys? Right? Easy case. Now there's a face only. Another toad. Good luck. Okay? Now here's our friend the arroyo toad. Third up. I don't know if I'm going to get through all this. I'm getting carded. Third up, the bat. The arroyo toad, the hapless toad, as then Judge Roberts. This is toad country. California. Love these lines. The ESA regulates takings, not toads. Okay? Retro bouncing? I don't know. The regulated activity is the planned commercial development, not the arroyo toad that it threatens. The ESA does not purport to tell toads what they may or may not do. Rather, Section 9 limits the taking of listed species and its prohibitions and corresponding penalties apply only to the persons who do the taking, not to the species that are taken. You see, this is the concept of worldview. How do judges view the world? How does the question come to them? In what frame is the question presented? And to this judge, this panel, the question was, it's not the toad, it's the economic activity. And of course, as I've said, once you get to economic activity, then you aggregate. And far from encroaching upon territory that has been traditionally been the domain of state and local government, the ESA represents a national response to a specific problem of truly national concern. Another big concern of the Supreme Court is that Congress should be acting on matters of national interest and national concern, and leaving things that are best left to the states. Well, this isn't that. It's, again, an international-based law. The preservation of endangered species is historically a federal function. I've already talked about that. And here's Justice Roberts. Now, this case is the case where a petition for rehearing en banc was held, and there were quite a few dissents, one of them by Judge Roberts, and Jonathan probably has something more to say about this. So I'm not going to try to tell you that there's a unanimity among the federal judiciary on this question, okay? So there's some disagreements here about not only is the law constitutional in every sort of application, but also what exact theory are you relying on to say that it is or it isn't. So but now we're going back the other way. Now we're going down the taxon, right? So now we're in a cave outside of Austin where a complex of bugs, cave invertebrates, live. This is an entire category, class, community, actually, an entire community of insects that live in one cave and nowhere else in the world. And there they are, or at least a couple of them. And some more. And some people like caves a lot. They like to crawl around in dark places and have bugs crawl on them. Do you like that? Go to Texas. So here's one of yours. Now we're in the Fifth Circuit. I dare anybody to tell me that the Fifth Circuit is some left-wing, wacko, whack-job environmentalist outfit, okay? Now we're in the Fifth Circuit, and here's Judge Davis. ESA is an economic regulatory scheme. Period. Bingo. Right out of the box. The regulation of intrastate takes of the cave species is an essential part of it. Therefore, cave species takes may be aggregated. Yada yada. Gotta hurry. Judge Dennis, in concurring, adds some nice little gloss to this. The conservation of the ecosystem upon which these commercial species depend may require the regulation of activities harmful to non-commercial species concentrated within a single state. Consequently, Congress has the authority to make a rational determination to conserve such non-commercial intrastate species as an essential and integral part of a comprehensive ESA program. Finally, this beauty. Another face only mother could love. Actually, very cool, prehistoric. So this is the last in these circuit court decisions. Now we're in the 11th Circuit, okay? So now we're in a whole new part of the world, Alabama, Florida, Mississippi. So this is the Tennessee Tom Bigby. Too bad Oliver isn't here because he and I remember fighting this. And Senator Moynihan once famously coined the term that the Tennessee Tom Bigby Waterway was the Corps of Engineers' attempt to clone the Mississippi River. And so they were going to go right through the heart of the sturgeon's habitat and raise havoc. Here's what the 11th Circuit had to say. Biodiversity's value is not ethereal. Its preservation produces economic gain in even the most narrow sense. For example, species diversity is essential to medicine. Half the most commonly prescribed medicines are derived from plant and animal species. I mentioned that. Congress could have excluded all intrastate species from the scope of the Act, but chose not to do so. The Court has no power to excise these trivial individual instances. Rushing along here, Congress was not constitutionally obligated to carve out exception for intrastate species. You get the idea. Now here we are in prairie dog country. Okay, so I got a few overlapping slides which I can spin through. Harming or killing Utah prairie dogs is prohibited by federal and state laws. Watching and enjoying them is encouraged. There they are. You've seen them. There's the recovery units. Steve's pretty well covered this. You know, here's one of the potential conflicts between, subdivision development and prairie dog towns, human towns, prairie dog towns. But, you see, here's the difference. We like to build things way out here. The city's way the hell over there. And we like to build them in all of these little enclaves that, are little cookie-cutter, ticky-tacky box things that we live in, like this, on the surface, take up a lot of space, put a lot of impervious cover on the landscape, a lot of runoff into the lake there, crapping that all up with algae. That's the way we do things. By contrast, we might learn something from the prairie dogs. They live on the ground. They live together with lots of other folks. They leave the surface areas for other folks to do interesting things with, and Steve's pretty much gone through that. He's gone through that. They do have symbiotic relationships. Some of them are a little bit, some of them are a little bit sketchy, right? They're a little bit risky, this guy, right? But they live together, they figure these things out. Others are, hoot. This is hoot, roaring owl. What to do with prairie dogs? Well, you can shoot them. That's one thing you can do. You can poison them. Another idea. You can watch them. Or, by God, you can commune with them. You could be one with them. So, there are all these tools. I mean, I love it when people say the Endangered Species Act is this rigid, jackbooted folks from the federal government taking my property and my branch is worthless and this is worthless and that's worthless and it's a horrible thing. There's never been a single case in over 40 years where any court, even the Claims Court, has ever found the Endangered Species Act to have taken any terrestrial property. Period. There's one weird case involving direct water contracts, but we'll leave that aside. The Endangered Species Act has never been held to be a taking of anybody's property under the Constitution by the most conservative court in the land, the Claims Court. So lots of different flexibility mechanisms. This one, for landowners to sign up for basically like a trading regime, offset regime. If you buy and contribute into this habitat mitigation bank, you get credits, you can graze, you can kill prairie dogs, direct or indirect, subject to certain limits. You can do all kinds of things. It's a market in prairie dogs. So there it is. Finally, boy do we miss him. What a loss this was. John Paul Stevens. So this is Raich versus Gonzalez. So Raich bookends the whole world of Commerce Clause jurisprudence. When I was in law school, when we were still learning by candlelight and writing on yellow pads, the Commerce Clause was a nullity. Nobody talked about the limits of the congressional power under the Commerce Clause because of Wickard versus Filbert. Because Mr. Wickard could consume his bushel of wheat on his farm in Illinois, and that was interstate commerce. And then we had Lopez and Morrison and all this other turmoil, and then finally with Raich versus Gonzalez, we came sort of back to the future, back to Wickard, with Justice John Paul Stevens writing the opinion saying, even the growing of one marijuana plant in your pot in Berkeley in your windowsill is interstate commerce. Because what if everybody was growing marijuana? Wouldn't that be interstate commerce as well as illegal? In fact, it doesn't matter, by the way, whether the commerce is legal or illegal, it's still commerce. So this is Raich, and this is Stevens' last contribution to us. Even if appellee's activity be local, and though it may not be regarded as commerce, because these folks weren't planning to sell their marijuana, they were. Julia, what do you do with marijuana?
Oh, I don't know.
Oh.
You inhale.
Thank you very much. That's what they were planning to do. They're planning to inhale it right there in the kitchen. So it may still, whatever its nature, be reached by Congress if it exerts a substantial economic effect on interstate commerce. We have never required Congress to legislate with scientific exactitude. When Congress decides that the total incidence of a practice poses a threat to a national market, it may regulate the entire class. In this vein, we have reiterated that when a general regulatory statute bears a substantial relation to commerce, the de minimis character of individual instances arising under that statute is of no consequence. But wait, it gets even better. Even Justice Scalia agrees. And Justice Scalia says, hey, this law regulating the pot of marijuana in the windowsill in Berkeley, Congress can reach it under the necessary and proper clause as a independent grounds of congressional authority. So I close with this. The man. To keep every cog in wheel is the first precaution of intelligent tinkering. I suggest we do that. Thank you.
And next we have Jonathan Wood with Pacific Legal. Please join me in welcoming.
Thank you. I should apologize in advance. I've been coming down with a cold, so my voice has been a bit unreliable the last few days. So I apologize if it conks out on me. I think the best place to begin this discussion of what the Utah Prairie Dog case is about and the 5 prior cases is actually to talk about what it's not about. None of these cases are about whether it's a good idea to protect species. I think it clearly is. That doesn't get you very far, because once you decide that, you then have to decide how are species going to be protected, at what cost, on whom are those costs going to be imposed, and what, if any, role are the varying levels of government going to have in that regulation. And that last question is going to have to be informed by the Constitution. All of you will remember from your constitutional law class or your basic civics class in high school that the Constitution establishes a federal government with only limited and enumerated powers. The police power, which is the overall power to regulate any human activity and pursue the public interest, is reserved to the states. That's something the federal government can't have. And the Supreme Court has insisted on that for over 2 centuries without any departure, any case that stands out and says, no, actually, they can do whatever they want. So really what these cases are about is a simple question. Does the U.S. Constitution give the federal government the authority to regulate any activity that affects any living thing? The answer to that question must be no, because if it can, that is the police power, that is unlimited federal power. To clarify why I say that has to be the question, I think it's important to discuss what exactly the take prohibition is. None of these cases are challenging the Endangered Species Act as a statute. That's not a constitutional claim. You have to look at a particular regulation and ask whether the Constitution authorizes that particular regulation. The take prohibition forbids any activity that harms any listed species. You were given examples earlier of trade, development, hunting. True, there are economic activities that can harm species, but the statute is not at all limited to that. Neither are the regulations that issue in the Utah Prairie Dog case. Lots of non-economic activity can run afoul of the statute. So, for example, I live in Northern California, and we have a jogging path around the American River, and every so often you see critical habitat, something called the Valley Elderberry Longhorn beetle. Well, if a beetle were crossing the path and I accidentally stomped on it while jogging, that would violate the statute. That would be take. It's certainly not an economic activity. Other examples, on the East Coast, Surfers violate the statute if they get within 5 football fields of a right whale. And finally, I think the key example that I always come back to is, if a rambunctious boy throws a rock at a protected species and hits it, that is take. That's harm to a species. And one of the important clarifications to make is that the harm to the species doesn't have to be the intent of the act. It doesn't have to be intended at all. A case from the late 80s out of the Ninth Circuit held that so long as you're consciously engaged in the act that ultimately leads to the harm, that's enough. So if you're driving your car through a rural area and just happen to hit a fly or some other species that's on the list, you've committed take. You've committed a criminal act that can be punished by up to $25,000 in civil fines, $50,000 in criminal fines, and a year in prison for every member of the species you harm. Well, that obviously imposes very significant costs on a lot of people and limits the type of activities that a lot of people would like to do with their property or do just generally. So, for example, one of the things I like to point out in discussing particularly the application of the Endangered Species Act to private property and the take prohibition of private property is that essentially what happened is, to greatly oversimplify things, if you imagine a species exists only on 3 plots of land, that's all its habitat, it's the only place it's found. The Endangered Species Act is the equivalent of 2 of the owners of those 3 plots developing their property, destroying the habitat and the species found there, then turning to the neighbor and saying, well, the species is now at risk, and we think it's really important that it be protected. So we're going to make you give up your right to develop your property. We've already acted. We've enjoyed the benefit of not being regulated. But you can't, because it's so important. We're not going to pay you anything for it. That's just, you're going to lose the right to use your property. This, because of the burdens that this imposes on property owners, a phenomenon called shoot, shovel, and shut up, it has been projected as one of the responses that if you see a regulation coming down the pike, you're going to destroy habitat on your property, destroy species found there before they become subject to regulation. Because ultimately what the statute punishes is those people who leave their property in a condition suitable for species longer than their neighbors. There are other consequences of the incredibly broad take prohibition. So, for example, you just heard about the Delhi Sands flower-loving fly. The issue in that case was the construction of a hospital. Because of the fly, the hospital had to be put somewhere else that was less convenient, which, and as I'm sure all of you know, that when you need emergency medical care, every second counts. People have literally died from that decision. And finally, the incredibly broad take prohibition can actually frustrate conservation. Just a couple examples of that. There are exotic hunting ranges in Texas that attempt to restore species that are essentially wiped out in the wild back in Africa, financed through hunting some of the members. And it's been wildly successful. But the truth is, all of that's take. And the Fish and Wildlife Service looked the other way for a while, but ultimately got sued. And it took congressional action to say, no, this is clearly good for the species. Why are we trying to stop it? Another example, I had the privilege of meeting a UC Davis student, PhD student, who was trying to help recover salmon along the West Coast. And his idea was to pay or get rice farmers to volunteer to allow their property to be flooded longer than they otherwise might to set up for the next growing season. And during that time, bring salmon onto the property so that they could have access to food and grow larger than they might otherwise do. And I asked him, did you have trouble with that? What was it like to get the farmers to go along with you? He said, actually, they were easy. The problem was the Fish and Wildlife Service, because I had to get permission to use the fish. That was the difficult part, because every time I caught them and moved them onto these farms, that was take. So, as you've been told, I am the attorney representing the organization challenging the Utah Prairie Dog regulation. My client is an organization of People for the Ethical Treatment of Property Owners. It contains about 200 members. They are residents, businessmen, property owners, and local government officials and agencies in southwestern Utah that have been struggling with this issue for 40 years. The protections of the Utah Prairie Dog regulation do have severe costs for a lot of these people. You were given some of the background. One of the things I think is actually interesting is that the 2012 regulation, which is the subject of this suit, actually restricts private property and restricts people's activities even further than it had been before, even though the species has increased substantially. At the time that it was moved from endangered to threatened, there were about 20,000 in the annual spring count of the species. In 2010, there were about 40,000, so the species had basically doubled. Nevertheless, Fish and Wildlife Service said, we're going to take a lot of properties and say, you can't even get permits anymore, and we're going to lower the number of oil permits for those properties still potentially eligible. And well, what has this meant for the residents of southwestern Utah? Well, if you own a empty lot in a residential subdivision, and prairie dogs show up, you can't build. And they like those lots because there are no predators for prairie dogs in these residential subdivisions, and there's a lot of access to food. You can't start your businesses. Probably the most significant impacts have been on the city itself. It cannot protect its recreational fields where children are supposed to be able to play from the prairie dogs. This defends them off. Prairie dogs have taken over the airport and dig under the runway and in the safety areas around it. And finally, they've occupied the cemetery where they bark during funerals, dig all over the cemetery and burrow all over the cemetery, and eat any flowers that mourners leave. And obviously, you can imagine putting yourself in a situation. It's extremely hurtful to see the final resting place of your loved one disturbed in this way. So they got together and they said, we're going to try to do something. There has to be a way to get back. And ultimately, we settled on a Commerce Clause, Necessary Proper Clause challenge to the take regulation. As I said, the take regulation forbids any activity that affects the Utah prairie dog. For that reason, it cannot be sustained under the Commerce Clause. For those of you that have taken constitutional law, Lopez and Morrison stand for the proposition that the Commerce Clause is limited in this area to regulating economic activity that has a substantial effect on interstate commerce. In those two cases, first in Lopez, it was about the federal regulation prohibiting possession of a gun near a school. The court said, obviously that's not economic, mere possession can't be economic. In Morrison, it was about gender-based violence. They said, obviously that too is not economic. But one thing that's important to point out is that instances of those can be economic. In fact, Lopez carried the gun to school because he was going to get selling it to a classmate. He was engaged in an economic act, but that's not enough to make a regulation a Commerce Clause regulation. You have to look at what is the activity being regulated on the face of the regulation, and is that economic? That wasn't the case in Lopez, it wasn't the case in Morrison, it's not the case here. Any activity isn't economic, and effects on species doesn't make it so. Finally, the substantial effects analysis. This is probably the area where the courts have varied the most. In the particular case of the Utah prairie dog, I think you have a difficult time. Basically, the government's arguments on substantial effects were, well, scientists have studied the prairie dog, so anything that affects them is obviously going to have a substantial effect on interstate commerce. But I would challenge all of you to come up with anything that you can't find at least one academic that has studied it. If the Commerce Clause's reach is everything that is a subject of academic interest, it's everything. They've also relied on some tourism, which happens on federal land, which isn't really an issue in our case because we're focusing on private land. Obviously, federal land can be regulated in the Property Clause. And this general idea of ecosystems affect the environment. Living things, or ecosystems affect interstate commerce. Life is essential to commerce. But that is a step too far. That's too attenuated to be a basis of constitutional theory. Because all of us affect the ecosystem. Yet clearly the federal government doesn't have the authority to regulate any activity that affects any one of us. That's what was decided in Lopez, that's what was decided in Morrison. And there's a lot of specific evidence about what guns near schools and what gender-based violence, how they affect people and how they ultimately affect the economy. And the court said no. Moving on to the Necessary and Proper Clause question. The Necessary and Proper Clause expands federal government's power beyond that in the Commerce Clause. It says that the government can regulate other activities if they're necessary to ensure that a comprehensive regulatory scheme works. But one of the problems is, and this comes out of Rage, is that Justice Stevens articulated the test about 5 different ways throughout the opinion. It's a very difficult opinion to read and follow. He doesn't identify where it's coming from. At one point he says it's a Commerce Clause test, at one point it's a Necessary and Proper Clause test. We finally had clarity in the Obamacare case or the Affordable Care Act case a few years ago when the Chief Justice said that no, it is in fact a Necessary and Proper Clause test. And that has some important consequences, thinking of this as a Necessary and Proper Clause test. Because that means that you're not in the world where you're dealing with Hodel or with Heart of Atlanta, the cases where the government was regulating commerce to pursue non-commerce related interests, to get rid of discrimination or to protect the environment. Under Rage, you can only regulate activity that is non-economic in order to make sure a comprehensive regulatory scheme works as a regulation of commerce. You can't pursue whatever general interest you're otherwise pursuing by regulating economic activity, because that's not the regulation of commerce. That's not what the Necessary and Proper Clause is about. And this is true across the enumerated powers. So for example, the government's power to regulate the military or people, the servicemen under the Military Regulations Clause is incredibly broad. They can essentially do whatever they want to servicemen to pursue any purpose, including reducing violence and regulating crime. But the Supreme Court has made clear that you can't go beyond that relying on the necessary and proper clause. You can't say that the government's interest in that crime can expand beyond regulating servicemen, even people that are associated with servicemen. That the limit is regulating the military in that case, and here it's regulating commerce. And that standard isn't satisfied by a take prohibition. And the reason is explained in the opinion, which I've passed out, and the notes, which I've also passed out. But basically it comes down to this. The federal government's ability to regulate a rambunctious boy throwing a rock at a Utah prairie dog does not implicate its ability to regulate any industry or any market for a commodity. Its ability to exercise its power under the Commerce Clause just isn't affected by that question. So because Congress went too far and defined take far too broadly, so this sweeps up all this non-economic activity that has nothing to do with industry or with commodities, it can't be upheld under the necessary and proper clause. And there's specific examples given in the opinion. So for example, we know that the federal government can regulate all kinds of activities affecting certain species like the bald eagle because there's a market for bald eagle artifacts. And so in order to protect, they can protect the species, protect the market for the byproduct of the bald eagle. But as I said earlier, a kid throwing a rock at a Utah prairie dog doesn't implicate the government's ability to regulate the market for bald eagle feathers or any other market for commodity. And the federal government hasn't even tried to argue that's true. Instead, the theory that they put forth is that, and I think it's along the lines of what you were told earlier, is that Raich just says, as long as it's an incredibly broad statutory scheme that has some effect on interstate commerce, and if it's a broad statutory scheme, that's always going to be true, then it's constitutional. So Congress could adopt a comprehensive scheme to regulate crime. They could adopt a comprehensive scheme to regulate land use. They could adopt a comprehensive scheme to regulate domestic relations. Anything that we have traditionally thought as exclusive provinces of the state governments are suddenly federal issues, so long as Congress adopts a broad statute. Now, I think the Supreme Court has already said that this can't be true in Lopez and Morrison, because in each of those cases, you weren't dealing with a standalone provision. You were dealing with a statutory provision setting out a particular crime that was part of an omnibus crime statute. If there ever was a comprehensive scheme to regulate crime, it was the statutes at issue, or the bills at issue in Lopez and Morrison. And the court gave no consideration to whether it could be upheld as part of a comprehensive scheme to regulate crime. Before I conclude, and my voice completely fails me, I think it's important to discuss what this ultimately means. I don't think saying the federal government can't regulate any activity that affects any living thing means that species can't be protected, or that it's a reason to be concerned about that. One, state and local governments can protect species. They clearly have the police power to do so. And in Utah, the state does protect the Utah prairie dog. It is listed under the State Endangered Species Act and regulated by the state agency. And that continues regardless of whether the 10th Circuit ultimately upholds a decision depriving the federal government of this authority. You can also have private conservation efforts, the purchase of conservation easements, or cooperation among private individuals. And finally, if the Constitution doesn't allow the federal government to regulate take, that doesn't mean the federal government can't do something else. It could, for example, provide a fair, what I think would be a fair regime and compensate people who give up their rights to use their property or engage in certain actions for the sake of all of us to enjoy the benefits of species conservation. That could clearly be done in the spending clause. The federal government maintains its power to control federal lands under the property clause, and that it too is able to do in Utah, despite notwithstanding the judge's decision. And finally, under the compact clause and the treaty clause, it can get a lot of people in the room and talk about how we can all work together to do this without going so far as federal take regulation. And with that, I'd like to open it up to questions.
One thing I never heard anyone speak about here is what exactly, once you take a prairie dog, what can you do with it? Are they edible? Is the fur saleable? What does one do with a dead prairie dog? Or are they simply killed as pests?
Prairie dogs are very interesting species. It's probably one of the few wildlife species where throughout its range, whether it's the Utah prairie dog or some other prairie dog, the rules of wanton waste, which typically apply to the killing or the take of other wildlife species, don't apply to prairie dogs. So basically, there's a whole national interest group called varmint hunters. They travel from state to state. They set up their long-range shooting operation, and they just plug away at prairie dogs without regulation. In almost all cases, there are no seasons, mostly, and then you can just let them lay. So that's one form of take.
Well, there's your interstate commerce, but keep going. Okay.
Well, just to be noted. But there's also landowners are permitted in almost every jurisdiction, with the exception of the Utah prairie dog, to go on their land and poison them. There's simply not that kind of regulation. So there's no use. People aren't tacking prairie dog pelts to their sheds or making use of their fur or any of their parts for anything particularly useful. There is a recreational shooting aspect, but that's the use.
I should say that, of course, other than the red wolf, none of the cases that have been decided dealt with commercially valuable species, or species for which there was any human use at all. So that's really not a relevant question to the Commerce Clause analysis, according to at least 5 of the circuit courts.
Is the Utah prairie dog relevant to any other endangered species? For example, is
The
it
ferret.
important to
It's
the
directly
survival
relevant to
of
the
the
ferret.
black-footed ferret, the burrowing owl? So it could affect protection of other endangered species.
Yes.
Well, the ferret is not known to have been on the Utah prairie dog as a predator, but there are other species that do: ferruginous hawks, burrowing owls, and then a suite of other sort of obligates. But
Just remember, though, that it's the wrong question to ask, what about the prairie dog? Because the courts don't look at it that way. They do not look at the question of just that one species, just that one location. None of them have. So you need to understand the legal framework is the whole ecosystem and how the species interact. It's not just one species.
But if the Utah prairie dog is important to the conservation of the black-footed ferret, then
That'd be
a
nice.
great deal of
That'd be nice.
importance to the endangered
Not
species.
necessary,
In
but
the
nice.
Commerce Clause.
In the case, the government put in some theory that it might matter for a couple of eagle species, but not that it's a significant food source.
Not legally relevant.
In the back.
Can any of y'all think of something that the federal government could not do based on the ESA?
Could not do.
Could not do.
I don't spend a lot of time thinking about things like that.
I could tell that already, but I'm just wondering.
That's just not a legal question.
It's a philosophical
We're
question.
talking about the scope of authority. Is there something the federal government can't do, citing ESA as a claim?
Well, it has to have a nexus to a protected species, and I disagree with Jonathan that any activity triggers take. That's not true at all. There's tons of case law that require harm to meet a much higher standard. Proximate cause, substantial interference with breeding, feeding, sheltering activities. Very few cases meet that test. Very hard to prove. Trust me, I've tried. Recent case right here, whooping cranes, 10 of them, dead in Texas. Fifth Circuit said, so what? So, no, it's not easy to prove a violation of the Endangered Species Act at all.
So I should say that obviously I think there are limits on what the government can do. So you just heard the standard for take caused by modifying habitat, but that's not the standard that applies across the board for take. Any activity that directly harms species is absolutely take and regulated. And that isn't limited to economic activity, it isn't limited in any way. And it's important also to add that we're not asking what is the limit of the Endangered Species Act, it's how are we interpreting the Commerce Clause. And so true to ESA is limited to endangered species, but the constitutional theory necessary to uphold it isn't, because there's no endangered species power. That doesn't come from the Constitution. So when I was arguing this case for the District of Utah, the government was asked directly, well, people are a species. If you think you can regulate activities that affect species, what limit is there on your power? And none was given. I think ultimately that's the reason why the case came out the way it did.
Yeah, go ahead.
I have a question for Jonathan. I mean, what's sort of the end game with this challenge? Like, is it to get the take provision entirely struck from the ESA? Because to me, that seems like if the individual mandate had been struck from Obamacare, the court would have just said Obamacare is gone, the whole thing. And it seems that the take provision has become so integral to the ESA that, like, I fear a similar thing would happen there.
I doubt that's true. So one of the just curiosities about the Utah Prairie dog case is that we have a species-specific regulation. As you were told earlier, it's not an endangered species, so the statute actually doesn't require any private activity affected to be regulated. But the Fish and Wildlife Service has adopted a regulation specific to it. So I think you'd have a very hard time saying the statute falls apart if you can't regulate Utah Prairie dogs, since the statute especially says you don't have to.
Right, I mean, that's what I was asking.
This was not a facial challenge to the take.
Okay.
It's not.
Yeah, it's not a challenge to the statute at all. It's a challenge to a particular regulation.
Okay,
of the species.
a particular
So
list.
read the language of the cases I cited to you that said that Congress doesn't have to excise species on private lands. It doesn't, the law doesn't require that.
I thought you were leading towards what are possible next steps. Is there a possibility for appeal
Oh,
to
it's
the
not
Supreme
appealable.
Court? And is
The
that-
briefing should begin in the next 2 months, and who knows when we'll have a hearing, but it should be wrapped up. The briefing should be wrapped up in the summer.
I want to follow up on his question because I'm not sure you answered it. And maybe you don't want to, and that's fine. But I think he was asking, what's your end game? What's your goal with this challenge? So you've described all the things you're not trying to do.
Mhm.
What are you trying to do?
I'm trying to enforce the Constitution's limits. I have a problem with saying the federal government has this sweeping authority to regulate anything that affects a living thing. That's an incredibly broad power, which the federal government doesn't have. And so that's my end goal. Ideally, ultimately, I'd like to see the Endangered Species Act be more cooperative and using a compensation regime that's more fair, rather than imposing incredibly severe burdens on people that I think did a good thing in allowing their property to remain suitable habitat for a species longer than everyone else. I think that's unfair, but the lawsuit doesn't get at that. The lawsuit gets just at what limits does the Constitution impose on the federal government's ability to do this.
Well, those are metaphysical questions, I just have to say. Where does federal authority end? How do you go about answering that? How do you answer that?
The enumerated powers. I can answer a specific question. I explained that here the problem is you're regulating non-economic activity, so you can't do it under the common
All the
law.
courts have said you are. How do you respond?
Well, so all the courts have said you are. But they've
Five
also
circuit
been-
courts.
Yeah. and-
5 times the Supreme Court has said they won't review it. That's not
Well,
settled in your mind?
I don't think the Supreme Court passing on a case has all that much significance, but the 5 circuit courts, because they pass on 99% of the cases, but the 5 circuit courts have not only, they've actually disagreed. They've criticized the rulings of the other courts. They have adopted conflicting rationales. And I think the biggest problem in the first 2 or 3 cases looked at just what is the activity being done by this particular plaintiff, not what is the statute regulating or the regulation regulating. That's the wrong question. If that were the question, Lopez would be wrongly decided because Alfonso Lopez brought a gun to school to sell it to a classmate.
Every one of these cases consider Lopez and Morris and Enrich, every one of them.
Right? Cases can be wrong.
Okay, we'll see.
Jonathan, how do you feel about HCPs? Because aren't HCPs supposed to kind of bridge that gap between federal regulation and trying to work with private landowners so that private landowners do feel that they're keeping their rights to do what they want on their land, but also not being detrimental to the species?
I would say they're probably a second best solution. They're happening over the layer of your already prohibited take. So it's almost like taking away a person's rights and then offering to sell it back to them. Saying, well, if you do what we want, we're going to reduce the burdens we've already imposed on you. That's better than just imposing the burdens, of course, but I would like to see a system where the government, or we all bore the cost of enjoying this public benefit of protecting species. I think that's the fair approach and what we think is good, rather than saying these few unlucky individuals have to bear all the costs for us.
Depending on the outcome of this case, if it goes to the Supreme Court, depending on what they rule, Is there a major concern, I guess I'm addressing this to you two, of the slippery slope argument? What implications do you think this will have for interpretation of what take is?
Well,
in
the way
Species
this
Act in the
case
future?
is framed, the most likely outcome would be a ruling that, as applied in this particular instance, there isn't a sufficient Commerce Clause nexus. It wouldn't strike the whole take prohibition, it wouldn't declare the act unconstitutional. It would be a nick, not a fatal wound.
We're out of time, I think. Thank you all for very interesting and stimulating discussion.